This is Alex Berger from Berger Law in Marquette, Michigan. Happy to report that Christina, Nestor, and I got a not guilty verdict on behalf of our client yesterday in Marquette County with about 15 minutes of deliberation by the jury. It was operating while intoxicated by marijuana with an occupant less than 16 years old case. And I wanted to share some things that happened in that case with you. First, I want to talk about what happened before the trial in terms of us filing motions. I want to talk about the basic facts of the case, what our defenses were, and then one interesting aspect of the case that I think is a good takeaway. So, as I said, this was an operating while intoxicated by marijuana case. The main investigating officer was Michigan State Trooper Blaine Borman. Trooper Borman is certified as a drug recognition expert. And that is a certification that law enforcement gets. It's the apex of drug analysis and interdiction for law enforcement. It supposedly gives them the ability to do a 12-step evaluation of a person they suspect to be impaired by drugs and determine what drug they're impaired by and if it impaired their ability to drive to the point that it was illegal. There's a lot going on here with drug recognition experts in the state of Michigan and the law regarding it. But basically, it's been really undermined. So we were able to use that law to ask the court to say that Trooper Borman was not allowed to be called a drug recognition expert. He wasn't qualified as an expert, and he couldn't give any opinions as to whether or not my client was impaired. We got an order to that effect before trial even began. So Trooper Borman basically was allowed to testify about what he observed, instructions he gave, and he was allowed to testify about what the field sobriety tests were. The basic facts of the case of this: Trooper Borman was driving southbound on M553, and he saw a car going the opposite direction, going 5 over the speed limit. For some reason, he decides to do a U-turn and follows the car, and supposedly while he's doing his U-turn and following, he sees that car touch or cross the center line briefly and then keep going. He also notices that the middle upper brake light is not working correctly. So he follows the car for a while. We have video of the last 30 seconds. So the dash cam in Michigan State Police cars starts 30 seconds before the overhead lights activate. So we have about 40 seconds of driving video. That's 30 seconds before the lights go on, and then about 10 seconds as the car pulls over. And it's perfect. There's absolutely no bad driving. No touching the line, no swerving, no weaving, no improper speed. The pullover is perfect. So that's what we have. We have evidence of pristine driving. Officer goes up to the car, sees a kid in the back seat, immediately asks about marijuana use, tells the driver, who's my client, I just need to check your eyes, and then I'm going to get you back on the road. Will you get out of the vehicle? So he commands my client to get out of the vehicle. He runs through field sobriety tests. He does more than just the eye test. He does 3 standard field sobriety tests and then 3 drug sobriety tests. And my client tells him he's sick. He's got bad knees. He's got bad back, bad shoulders. And he's really nervous and stressed out. But Trooper Borman does not think that those things might be attributed to how he's performing on the tests, and he arrests him. So at trial, our defense was essentially that he was sick. If there was any deficiencies on the field sobriety test, that was because of his sickness, not because of marijuana impairment. The defendant did admit to using marijuana about 5 hours earlier, just a little bit, to help with the nausea for his sickness. And the trooper thought that that was enough. Trooper did ask on a scale of 0 to 100, how impaired are you right now? And my client's answer was a 1. Trooper Borman took that as an admission of impairment. So 1 out of 100 is an admission of impairment to Trooper Borman. But this was a really good example of Trooper Borman being absolutely sure that my client was too impaired to drive. And giving a lot of good reasons for it. Trooper Borman did very well on the stand. But then what really our defense was is my client took the stand during our case, and he explained how sick he was. He explained that he was admitted to the hospital 2 days later with a severe temperature of 102 or 103, and he had very strong dehydration. and that had been going on for a couple days. So he was really sick when he got pulled over. He also testified that he had a lot going on in his mind at that time. His mother had just been diagnosed with cancer. His wife had just gotten a really bad medical diagnosis, and him and his daughter were sick. He was going to pick up his wife to take her to the doctor. So he did a good job of explaining what was going on in his head that day, and the jury came back with a verdict of not guilty. I think they must have deliberated less than 10 minutes. Chose a foreperson, talked about it very briefly, and came back with a not guilty. I do think that it was my client's testimony that really got us over that hump, but it was also the driving video. No bad driving in the video. And so the one piece of information I thought was interesting from the testimony from Trooper Borman was, I asked the question I always do, was my client free to refuse the field sobriety tests? And Trooper Borman said yes. They don't have to do them. You can't get in trouble for not doing field sobriety tests for refusing. And I asked Trooper Borman, what would you have done if my client had refused field sobriety tests and had refused to answer any more questions, which is his right? And Trooper Borman said he would have ordered him out of the vehicle to observe him more. And he said that would be a lawful order, which means that if you refuse to speak and refuse to do field sobriety tests and the officer orders you out of the vehicle and you refuse to get out of the vehicle, you could be charged with a felony resisting and obstructing. And I think that's what would have happened here if my client had just straight up refused to get out of the vehicle. And so that's an important takeaway, is if you do refuse the field sobriety test, if you do refuse to answer any questions and the officer orders you out of the vehicle, if you don't get out of that vehicle, you could be charged with a felony. But it was a good case to try. I'm very glad that the verdict was swift and clear, and I hope that it'll cause prosecutors to rethink actually taking these cases to trial and give some better offers. Thank you.